I want to thank Deborah Meyer Morris, who had the idea for this panel kind of in passing at our September kickoff meeting. And she was like, how about if you go on the First Amendment? I know that Eugene at the Ventura County Colleges of Law. And I was like, yes, please make it so. And it is so. So thank you so much, Deborah. Deborah's also from me, and a Camarillo branch member, and also a member of our public policy committee, led by Kathy Long. So obviously the First Amendment is just one of many right now where we have some concerns, and we are really delighted to have this amazing panel of professors and students and recent graduates and folks who are really committed to this work and protect, issues around the First Amendment. So I'm going to introduce Brandy Price. Brandy is the Dean and Chief Academic Officer of the Colleges of Law. Her previous leadership positions include Accreditation Liaison Officer to the WASC Senior College and University Commission, Associate Dean of On-Site and Special Programs, and Associate Dean for the Hybrid JD program, one of the nation's pioneering programs integrating online and in-person legal education. Prior to joining the Colleges of Law in 2020, Dean Price held senior academic leadership positions in California-based charter schools, including Chief Academic Officer. She earned her JD from the University of Pennsylvania Law School, her Master of Education from UCLA, go Bruins, and her bachelor's from the University of California, Irvine. We are really delighted Dean Price pulled this panel together, and we're really excited to have you all here. And she's going to introduce our panelists and get the ball rolling. Thank you so much.
Yes, thank you so much. I was appointed Dean in July of last year, and one of the things I asked a lot is like, what are your priorities as a new dean? And one is to tell the story of the school. So I'll just quickly tell you about the Colleges of Law. We have campuses in Ventura and Santa Barbara. We started out back in 1969. It was a handful of attorneys in Ventura who said we need a law school that's geographically close, that's affordable and accessible, and that's been our mission, our entire existence. So very honored to be the dean of the school, and very honored to be with my fellow panelists who have graciously offered to be here with me, and very grateful for Deborah and for all of you to have the opportunity to speak with you today. So with that, I'll start with Professor Eric Lane. Eric Lane is the Eric J. Smirtz Professor of Public Law and Public Service Emeritus at the Maurice A. Dean School of Law, Hofstra University, where he served as dean from 2012 to 2017. Among the courses he has taught are constitutional law, legal history, law and literature, and international law. He is currently teaching constitutional law at the Colleges of Law. We're very lucky to have him, Santa Barbara. So Professor Lane's extensive experience includes service in state and local government, authorship of law textbooks, nonprofit leadership, and various roles as an attorney. He received a BA from Brown University, an MA from State University of New York, a JD from Fordham University School of Law, and an LLM from NYU School of Law. So an incredibly accomplished professor, and very thrilled that he's here with us. To my right is a current student at the Santa Barbara campus. Allison Wooten is a third-year law student at Santa Barbara Colleges of Law, where she focuses on constitutional law, criminal law, and appellate advocacy. She has received multiple academic honors, including the Dean Heather Terjakis Award winner for appellate advocacy, and has extensive experience in legal research, writing, and oral argument. As a mother of four, Allison brings a generational perspective to free expression, emphasizing the importance of preserving a civic culture capable of tolerating dissent and disagreement. Don't we need that right now? She plans to pursue a career in public service as a deputy district attorney, focused on public safety, accountability, and the lawful protection of victims of violence, particularly women and children. And last but not least, Massimo Genovese, and it's his birthday today, so he's spending his birthday. And he's quite incredible. When I asked him to serve in this panel, he said it's the perfect way to spend my birthday. He means it. So he's a graduate. He graduated in December. He's currently preparing for the February bar exam. So he's a graduate now of the Colleges of Law and UC Santa Barbara with an interdisciplinary focus and passion for law, ethics, philosophy, and science and technology. So I think we're going to learn a lot. So just to give a little overview of how I'm going to approach the panel, I'm going to paint broad strokes around a current issue we probably all heard about or read about. And then I'm going to give our panelists an opportunity to, in that broad sort of overview of a big issue that's happening now, contemporary issues, give us their perspective with the idea that I tell law students all the time, excellent attorneys are excellent teachers. And our goal today is to teach us some of the language with which we can talk about some of the things I know our friends are talking about and certainly our country at large is talking about. So I'm going to start off and then I'll just go panelist to panelist to share what they want about whether this implicates the First Amendment or not and why. So again, to give us, we hear freedom of speech all the time. A lot of times it doesn't really implicate freedom of speech, but we do hope to teach and learn together with this panelist. Like I told them, we're teachers today, and we'll learn from you too. And we'll leave the last 10 or so minutes for questions from you. So the first sort of broad stroke, the pro-Palestinian protesters at Columbia University. Who heard about that? Yeah, like you put it not, right? So what ended up happening is there were pro-Palestinian protesters on the Columbia campus. And then ultimately, Columbia banned the encampments because there were encampments and then brought in law enforcement. So that's all I'm going to say. And then we're just going to go panelist to panelist to talk about whether the First Amendment was implicated and why. And we'll start with Professor Lane.
Well, the first thing you have to understand is Columbia University is private property, not a governmental setting, and the First Amendment only stops Congress and states from restricting free speech. So that doesn't mean that Columbia doesn't have its own rules. It does have its own rules, and they are very similar to the First Amendment. But the First Amendment itself is a provision of the Constitution, doesn't immediately restrict Columbia University's treatment of its students with respect to, unlike, for example, those at the University of California or any public university, there the First Amendment would be applicable. But when they call the police in, similar to that, it changes the mood of the scenario that the First Amendment actually gets applied for reasons that are a little bit remote, because it really has to do with can the police, what the police acting, now the police are restricted by the First Amendment. So the basic rule there is that protests are permitted, protests are encouraged if they're peaceful, and particularly at a university where the exchange of ideas and even the heated exchange of ideas within reason are valued as opposed to repressed. That said, there are a number of rules that guide that. One of which is you can't, for example, block students from going to class. Another is that you can't stand in someone's face and scream at them, you hate Israel, or, in their face. You can't disrupt classrooms, and you have to, there has to be a level of peace. These are limitations. So when we talk about the First Amendment, I don't want to take too much time, but if you talk about the First Amendment, doesn't mean we can say anything we want anytime we want. We can't do some stuff. There are a number of uses of language which are not protected by the First Amendment. Fighting words. You probably heard, or some of your lawyers definitely heard, calling fire in a crowded theater. Can't do that. Obscenity is not permitted. Threats are not permitted. Immediate threats of violence are not permitted. It's one of the debates that went on over January 6th. Did the president encourage people to riot, or did he simply use his free speech to talk about how he's been cheated out of the election or something? So there are a lot of restrictions on that. But as a basic thing, the Columbia issue got out of hand because it was so disruptive. People were stopped from going classes. Fighting words were used, threatening words were used. That's battle was over with the police. Sorry.
Thank you, President. That was perfect. Allison, what are your thoughts?
Thank you, Bryce. One thing about Columbia that I think stirred up a lot of consternation was the fact that funding was later withheld by President Trump, $400 million, I believe was the amount, tied to these lack of action around the protesters, right? So even though Columbia is a private university, governments can sometimes implicate the First Amendment when they have something called state action. And state action is where the government either coerces a private company or entity by words or conduct, or they are so instrumental in the decision-making of that company that they become a puppet of the government. And so the argument that a lot of people were making was that by withholding this funding for research, you are basically manipulating Columbia into doing what you want them to do. The Trump administration, as I understand it, used the cover of Title VI, which is the when people are being persecuted based on race or religion, then the government can step in and they can say this is not appropriate. And so they're saying that there was anti-Semitism on the campus, that Jewish students are being persecuted by these protests. Title VI has a very high bar. You have to be basically blocking access to classrooms, to housing. It has to be genuine fear for safety or harassment. And so it depends how you view the actions and the speech of the government, whether or not it's in violation. If you believe that they are indeed protecting students under the auspices of Title VI, that there was anti-Semitism, that they are protecting these students, then the defunding can be more palatable. If instead it's simply the government reaching to control the message of the protesters, saying, we don't want you to say that, the state action doctrine disallows that, because the government cannot decide what you're going to say based on the content of your message. It can regulate in certain ways that we'll get into, time, place, and manner, but never to destroy your speech on the basis of the content of your message is the hardest bar to meet. It requires a lot of hoops to jump through. So Massimo is very knowledgeable on this topic, so I'm sure he'll have more to say, but I really think it's important to look at what the arguments are being made, because there's safeguards everywhere in the Constitution, but free speech is just like the tipping point of this issue.
Okay. So that was a bit of like I'm going to start abstractly. It's going to be kind of like a civics thing. And I'm going to ask the question and you can just blurt out the answer if you have it, unless you are a lawyer or have been to the law school. So if we're all talking about state action, which is extremely important in your constitutional law analysis, certainly the First Amendment, state action is a prerequisite really for any of these issues. And so it seems hard to believe, but the federal government is supposed to have enumerated limited powers, and the 10th Amendment gives the rest of the power back to the states and the people. This also includes the entire Bill of Rights and the First Amendment. So what state action means is essentially the state needs to be the one acting. So here's the question. What part of the Constitution do you think restricts your actions as a private citizen, setting aside entanglement issues for a moment? What part of the Bill of Rights or beyond the Bill of Rights? If anyone knows, just blurt it out. Which amendment, generally speaking, restricts your actions? It's kind of a weird, but it's a good teaching convention to show you how state action works. So the 13th Amendment, prohibition against owning a slave, restricts your private action. You cannot own a slave. You're not the state. A state is not acting, right? So this is one way that you can remember whether or not there's been state action is, well, the Constitution is not limiting my ability as a private citizen to do something. It's limiting the government, right? That's what it's doing. It's limiting their actions. There's also entanglement issues. If any of you are very, very wealthy and you end up owning a town horizontally and vertically, who typically owns towns? The sovereign state. The Constitution will likely apply to you in that situation. And there's other situations too, racially restrictive covenants, all these things. But applying it to this here, Columbia, like the professor said, is private. So immediately, our threshold issue, probably the first thing we should always think about is there state action? Is there entanglement? The professor also spoke about the police showing up. Clearly, there's state action. So in this situation, you need state action. Really, everything we're going to talk about today, pretty much, there needs to be state action to start our First Amendment analysis. This also, this whole question relates to the, Mahmoud Khalil, right? There was another, it's kind of a different issue, but basically the administration is being accused. The plaintiffs are saying this is a viewpoint discrimination, which you talked about, right? If the government is trying to restrict our speech based on a viewpoint, subject matter, right? They call this content-based restrictions. We have the most protection there. The government has a very, very high burden of persuasion in order for that law to be permissible. So in this case, if that were happening, it's private, so already we don't have state action, perhaps no issue. But if that's what the police are doing, if that's what the state's doing, in this situation with the visa, there's a recent development 2 days ago. A judge issued a remedial sanction saying that those students, if they're basically if there's some sort of retribution or change to their visa status, it's going to be considered presumptively retaliatory unless the government can prove otherwise. So long story short, the court, that judge is saying, hold on, let's make sure that you're not going after these students for whatever it is they're talking about, Israel, Palestine. The administration, Marco Rubio, Trump, they're all named, right? They're saying, oh no, this is run-of-the-mill deportation, independent of the content, independent of the speech. We're not, that has nothing to do with the message. It's neutral in some manner. So that is my opinion there is basically in line with what we just heard. There is state action requirement. Columbia is private. We can get into the weeds if there's some entanglement issues, but it definitely doesn't it doesn't look good if the government goes after someone and then after the fact you hear officials saying it was because of that, the content of their speech. Clearly that's not a good look. But I'd say for the rest of the discussion, we've established a good threshold issue to discuss, which is state action. And that's something you should probably always remember, because in a regular First Amendment debate, you're going to hear people say, well, you can't do that. That's my First Amendment rights. I'm your neighbor. I'm not the government. Maybe there's a private tort, maybe there's a crime, maybe there's that, something, but we need state action. So that's
Thank you all. So we'll turn to Jimmy Kimmel, right? So Jimmy Kimmel, if you recall, made some remarks about Charlie Kirk's death. And then Brendan Carr, who's the FCC chair, basically said, we might have to discipline drop that show. And do we know what happened? Jimmy Kimmel was suspended by ABC. So let's hear more about how the First Amendment was or was not implicated, and if so, how. We'll start with Allison.
So this was recently, but it doesn't feel so recent because so many things come out in the news. It feels like, oh my gosh, did we remember when this happened? But basically it's the same idea, right? So it's a private company that runs Jimmy Kimmel show. So at first blush, you think they can do whatever they want. They can suspend them, they can do whatever. But they are licensed by the FCC, which is a government entity, part of the government. And so the words I believe the FCC chair used was, we can do this the hard way or we can do this the easy way, right? And so there's something called jawboning. So it's a term that discusses how governments can use coercive language or threatening language to be so antagonistic or controlling towards a private entity that it, again, becomes state action. And so the discussion and decision that you have to make is a comment like that, we can do this the hard way or we can do this the easy way, coercive enough to meet that state action burden, right? Jimmy Kimmel did get his job back. So the people who argue that it was just maybe, tough talk or things like that, they say, well, it didn't amount to him actually losing his job. The First Amendment concern is that when we start to have actual action by private companies, even a suspension that you're later reinstated to, it seems to me, who I'm more of a free speech absolutist, that we're getting into the controlling and coercive behavior of the government of a private entity. So I do not encourage it. I don't think it is the FCC's job to make comments like that, especially publicly. If you want to have a conversation, or if you're really just having emotions about it, government speech is allowed. But when you threaten licensure, for me, it crosses the line into punitive action, which meets the state action bar.
Thank you. So this situation was kind of weird for me to talk about because it's obviously, there seems to be a ton of circumstantial evidence here, but it doesn't look good to me. The comments of the podcast, right? It turned out to be a little bit moot, but it came back up this week. If you've read the news, it's Jimmy Kimmel saying there's pressure once again. There's a rule, there's a case, I think Red Lion is the Supreme Court case. Broadcast media has slightly different First Amendment principles because the Supreme Court long ago said there's a technological singularity here, meaning there's not that many ways to broadcast. For instance, on the radio, there's only so many channels. And because there's only so many channels, the Supreme Court has said, well, the public, there's not infinite options. There's like infinite web pages, but there's not infinite options on the radio. And so they assess this area, and the FCC does things a little differently. They look at the public good and they weigh it a little bit higher than that private interest in speech that the speaker might have on those channels. They got rid of something long ago, the fairness doctrine, which used to allow you to basically rebut someone who said something about you. You had to let them on, kind of a weird, crazy concept for the First Amendment. But now we have a situation where the FCC, they make sure there's not obscenity on there. They make sure there's not fraud on there, right? You don't want that on your broadcast channels. But now, and I think in this past week, they're looking at whether or not these comedy shows and stuff are going to be part of this exemption that they've been a part of for a long time, where they're basically news broadcasts. And they're saying, well, oh, you know what, maybe you're not going to be exempt, and we're going to apply this sort of different standard to you. With Jimmy Kimmel, again, we're talking about issues like obviously government coercion. The FCC chairman did say that on the podcast. The president sort of, after the fact, sort of ratified it by saying, oh yeah, you're terrible, blah, blah, this is great, right? That doesn't look good. That looks like a viewpoint discrimination potentially, right? It's a ton of circumstantial stuff, but it certainly doesn't look good. It also doesn't look good that the company, the conglomerate in charge of Disney, which owns the subsidiary that owns Jimmy Kimmel's show, apparently wants to purchase or do some sort of merger that requires FCC approval, right? It doesn't look good. And then it looks like they're immediately capitulating circumstantially to silence Jimmy Kimmel because of what he said that day about Charlie Kirk. Tons of circumstantial stuff, certainly doesn't look good. Possibly state action, possibly viewpoint discrimination. Not really sure. I mean, kind of sure. We'll see. Somebody needs to sue somebody, but the whole thing though is still live, because if the FCC ends up saying, oh, you know what, these comedy shows, they're not exempt. They're not these. If they put them into that new category, they're going to actually impose standards, these interesting standards on them. So all of that said, coercion and a licensing system is a prior restraint. Prior restraints are, on their face, unconstitutional restrictions on the First Amendment. A prior restraint is essentially a license. There's other examples, but if you're licensing, if you have unfettered discretion to give licenses to speak or to publish things, impermissible generally, unless there's time, place, or manner, things like a kind of parade or something down the street, then you can have a license, so long as you're not discriminating based on viewpoint. In this situation, we got all kinds of stuff going on. It's not really saturated yet into a justiciable, like something that we don't really have an answer from the courts, but it doesn't look good. It could be viewpoint discrimination, certainly. And we'll just kind of have to wait and see. There's developments going on right now. Every day is just crazy. So we'll see.
Massimo said somebody has to sue somebody. He's already ready to go.
Absolutely.
I want to take a step back first a minute. So the original Constitution, which gets ratified in 1787, did not contain the Bill of Rights or the First Amendment. And the reason it didn't are many reasons, but one of which, the main one, is which the founders believed that this was a state issue. In other words, it wasn't their job. They wanted really just to put the nation together. They weren't thinking about it. And what happened was that a number of states said they did not ratify the Constitution. There wasn't a Bill of Rights. And so James Madison and Hamilton and the leaders said, okay, ratify the Constitution. The first order of business for the new Congress will be a Bill of Rights, which is what happened. And so by 1791, there was a Bill of Rights, and the First Amendment was part of it. And within 9 years, the Congress of the United States passed what was called the Alien and Sedition Act. So that was in the first year, the last year of the Adams presidency. And I'm telling you about this because a number of members of that Congress that passed that had also supported ratification of the Bill of Rights and the Constitution. Now, the thing the important point for the First Amendment that act included was it was against the law to criticize the President of the United States. So 9 years after it, they pass a law that says it's illegal to criticize the President and a number of his cabinet officers, but omitted from the list of people that it was unlawful to criticize was the Vice President. You could criticize the President. And in fact, the editor of a newspaper went to jail for this for sure. And the reason why you could criticize the Vice President was because the Vice President was Thomas Jefferson, and Adams hated Thomas Jefferson. And Congress, which was controlled by Adams' party, which I think at the time of the Federalist Party, also hated him or followed along. Now, this may seem familiar to you from today, but what's particularly fascinating about it is that a number of people that supported this act also had supported the Bill of Rights. I mean, it was 8-year difference in time. So one of the things that this should definitely demonstrate to you is sort of the frailty of humans when power was at stake, that the first thing you're going to want to do is to stop people from criticizing you, which is at the heart of the First Amendment. Political criticism is the number one part of it. And we see off and on over the years, even though the Supreme Court never paid attention to this again until probably Governor Warren became the head of the Supreme Court, we started to get back into considering the amendment as important. But you can see today how important this, how needed this kind of restraint is if you want to maintain a democracy, which is key, which is depends on criticism back and forth and the education through criticism. So getting to that, that's just the background of this. I want to go to what both Mr. Massimo and Ms. Wooten said about this one thing the dean brought up about Jimmy Kimmel. So this is really a new area, although there have been cases about this, some law on this. But we've never had a presidency which saw that criticism was to be met with threats. So, and I mean, for example, he just added, he's suing the New York Times right now, and he just today or yesterday added the fact on polls that the polls were, the Times published a poll that showed them wasn't favorable. He's adding that to a lawsuit. So there's a real frequency and intensity about this desire to stop criticism. And so when Jimmy Kimmel gets, be careful there, because one of my sons is a high executive at Disney and has some involvement in this thing. Very careful. But when he was suspended or put on leave for 2 days, whatever, and then the what's the name of the guy that's the head of the the head of the FCC said, you better pay attention to what we're doing. That is a real potential, and I know there's no case on it, violation of the First Amendment. Why? Because of the threat of using government power to restrain talk, particularly political talk, because remember, he's being punished or threatened punishment because he criticized said something about, Charlie Kirk that was pretty modest. The quote, what he said, and that showed that he was criticizing sort of this newly invented hero of President Trump's and the administration. He was threatening the entire station. We're threatening your license. So that's really the heart of it. But we're seeing this more frequently now, a lot more frequently, where criticism is leading to some threat. Ms. Wooten mentioned the threat to withhold money from Colombia, clawing back of money, what they call it, or stuff, money that hadn't been yet distributed. That again is the same thing. It's slightly different because Colombia is not criticized. So it's not really the criticism of the First Amendment rights of Colombia, but it's again using coercion to try to get results that they want in that case. But it could be in the same way. For example, if you use coercion to try to against the dean here to try to get me to not say certain things in class, that would be the same idea to violate my First Amendment right. So this is something you have to really pay attention to. The courts are just starting to get some of these cases. Who knows what can. I always tell my class when it comes to the courts, I always tell my class, if I ever say anything's 100% sure, I promise you it's only 80% sure. The reason is you got human beings stand right in the way of what I'm clearly right about. Sometimes they just don't agree.
We'll move on to something we hear from folks on social media, like I'm in Facebook jail or I've been deplatformed. And I want to talk about that, like whether it implicates a person, because you hear it, right, from folks. They'll say, oh my gosh, my free speech rights have been violated because I've been knocked off, X. But I want to hear more about that. And then I have a second part to this big picture anecdote about what if the government, because I think some revelations have come out that the Biden administration was pressuring Mark Zuckerberg around COVID-ness during the pandemic. So both parts, like, does it implicate to getting deplatformed or, suspended from a social media platform? Does that implicate the First Amendment? What about that question and answer? And then what about when an administration is pressuring, admittedly, a social media company in terms of the content how it manipulates content? And I'll start with Massimo this time.
Okay, so yeah, deplatforming is, in my view, kind of a cutting edge area of constitutional law because there's unanswered questions about whether or not these platforms are, what kind of forum they are. There's at least 4 forums that we analyze the First Amendment under. Public forum is the quintessential sidewalk, right? You can't do viewpoint restrictions generally unless they're very, very narrowly tailored or time, place, and manner. You can't restrict what people say on the sidewalk. Well, what if Facebook is the sidewalk now, digitally speaking? What if who's doing all their debating on the sidewalk? Some people, most people, right? It's kind of weird. So that's a whole question, and it's up to the courts. There's Clarence Thomas has said some things. People have said things, but who knows whether or not they're, public forums, private forums, etc. These are clearly private companies for now. So that has implications as to whether or not, if it's a private company and they want to boot you off, then again, state action. We're back to what we initially started talking about. That's it. When it comes to the Biden thing, we're back to government coercion and whether or not, and with government coercion, you have to remember that there's the government speech doctrine. The government obviously speaks through its officials, right? They say stuff every day. The government has its right to speak that is sort of irrespective or sort of detached from everything else we've been talking about. However, if the government speaks in a way that's, if they can't speak in such a way that's subjugating our ability to speak, right? That can be coercion and right back into what we're talking about. But if the government wants to, the officials have opinions on things. They might have opinion. They might talk to companies about what they do or don't want them to do. Once we transition into coercion, it's a whole different story, and we're back to, potential discriminatory rules. When it comes to spending, right, which isn't really what you But when it comes to conditional spending, that's a form of government speech as well. It's usually judged under the lowest sort of tier of the lowest test. In other words, the government, when they pull money from an entity or from a state, the Supreme Court has said it can't be unduly coercive, and it cannot be that they're pooling the money to suppress speech that is completely irrelevant to what they gave you the money for in the first place. So it's kind of a mouthful, but basically what they're saying is like, you can't take money, the government can't take a bunch of money away from a company or something just to suppress their ideas because they don't like what they're saying. That's not okay. But they certainly can give their opinions. We live in a federalist, we have dual sovereigns here. So California's government officials, as you probably know, have very different opinions. You saw what happened overseas recently. California's governor might say something and completely disagree. He has the right to speak. The president has the right to speak. They may not agree. They might have things they want to say to private companies. We really need to transition into regulations, coercion, suppression of speech to get into actionable areas of what we're talking about here. So back to the platforms, the government is able to say what they want, but they can't tread into coercion or try to suppress what Zuckerberg is saying, or basically force Zuckerberg to say what things he doesn't want to say. And real quick, last note is there's a whole situation where with these platforms, when they don't want you to say something and they deplatform you, I'm saying that on its face, that's fine. We have Section 230, which says that these platforms are not necessarily, they're basically not liable for the discussions that go on the platforms, right? Section 230 is, I guess, somewhat controversial, but you can't sue Facebook because people planned to do a really bad thing on Facebook, right? You sue those people for whatever it was they were planning. And so it's a kind of a complex cutting edge area. I don't think that there's too many clear answers as to what kind of forum it is, but certainly they can kick you off. They can kick you off Facebook, and I don't think you have the ability to sue them because there's no standard.
So I'm going to preface this by saying that my feeling as a free speech absolutist and as what I like to believe an independent-minded woman and with a mother of children looking forward into the future, I feel that the polarization of our politics has precipitated a large portion of the assault on the First Amendment. And what I mean by that is when we feel a part of a team or we believe a certain message, we feel that it is okay to perhaps suppress messages that discount that or that go against our firmly held beliefs. And I understand the desire to create more areas of speech that is not protected, right? Because I do have kids, and there's parts of the law that I feel like they deserve more protection. But the fact of the matter is, the First Amendment issues we're seeing today did not begin simply with the Trump administration, right? And so even if you're a Democrat or you're a Republican, it's important if you believe in the First Amendment to say that is a violation. And so in the cases of the suppression of the Biden administration upon certain messaging in Facebook or different social media companies around COVID, right? So in my First Amendment class, we actually read these decisions. There was some out of Missouri, some out of Texas, and looked at what was happening day to day with the Biden administration and Facebook. And in the examples that were presented in these cases, the Biden administration was meeting daily with the Facebook administration, was giving them pretty cut and dry directions of what they should be doing to suppress, anti-COVID speech, disinformation, whatever you want to call it. And it doesn't matter to me whether you believe any part of the government speech, right? That is not what's important to me. It's when the government, under the auspices of whatever it is that they are claiming, tries to curtail private speech without going through the proper channels, right? Meeting strict scrutiny if it's content-based, meeting intermediate scrutiny if it's not. I don't think the government can just go meet in a room with officials and of companies and say, you have to do this because it's a safety issue. If it is, then come out in the public and let's discuss it all together. So I feel that was sort of you know, obviously there's been assaults on the First Amendment by administrations in the pursuit of power forever, right? Because that's what governments do, right? They want to control things, and that's a lot of the reason why we elect them. But if we're going to be disturbed by what's happening today, I think we should also be disturbed by the way that Facebook was controlled by the Biden administration. The court did not find it that way. The court voted it down primarily based on lack of standing for the suits that were in effect. But if you go back and you have a lot of time on your hands, because they're very lengthy decisions, to read and see how these conversations were being held, one part of state action is coercion, but it's also being the decision maker for a private company, right? You're effectively deciding for them what they're going to do. And in my opinion, the Biden administration was deciding for Facebook how they were going to either promote or deplatform certain messages. And so I just think it's so important that we always pursue the protection of the Constitution and the First Amendment, regardless of our personal political beliefs, because I don't trust those that don't agree with me, and I don't trust those who do agree with me. I trust the Constitution and the way that it has protected us since its inception.
Hold the mic closer. Thank you.
Well, I just want to go to the last thing Ms. Wooten said. Trusting the government is people. And trusting the Constitution, for me, is too abstract. Because there have been many times where, you know, Plessy versus Ferguson, Black people have no rights. No, that's not Plessy. Dred Scott. Plessy versus Ferguson, separate buddy. So it's hard to just trust the Constitution. It has to do with human beings who are charged with its interpretation, and it has to do with the public that hopefully continues its its watch on what people who have responsibility are doing. On the Biden administration, I'm a Democrat. I don't approve of anybody meddling around with the First Amendment. But then, of course, there's the question of where the lines are drawn. So, for example, going and telling a president of a company that he thinks what they're doing is obscene, and they may bring an action against them for, you know, setting who's not protected. And there were many claims about Facebook allowing setting to be part of their now. Facebook is allowed to do it. They can suffer lawsuits, but I don't think there's anything wrong with the government trying to limit various media entities from using obscenity. It's a big issue starting right now, maybe with these AI drawings. For example, Reese Witherspoon recently complained that there were nude pictures of her and obscene pictures of her appearing as a result of some people, you know, fiddling around with AI, taking her face and her body, and then just taking the clothes off it or manipulating the body. And this is all going to become an issue. I mean, it's a civil issue in the first instance because of the that it's not a state action. But on the other hand, the whole issue of how media, digital media is going to be regulated is really up in the air right now. It's a lot of money being spent back and forth trying to lobby and the like. And so, you know, I don't think we have the answers to that yet. In California, the use of her image would probably violate the criminal privacy list that they have, although, you know, no actions have been brought yet. It's a long wait to see. But going back to the dean's original point, I think that, you know, I have to agree with both of the students, or almost lawyer, almost graduate. And I mean, you don't want government strong arming, period, whether it's without threats or with threats. You don't want them strong arming And I think more importantly, in my mind, to say you have to trust the Constitution, I think I would say you shouldn't be trusting the instincts of people, presidents, Democrats or Republicans, when it comes to trying to avoid the kind of criticism that we protect by the First Amendment. I think you should always be skeptical if you see a president of the United States or any elected official of any party trying to, be thuggish with the media because their instincts, like anybody who wants to be criticized. I mean, I look at those ratings, professor ratings, in a rage if there's a single criticism. Now, I can't stop that. I probably would have tried, but when I was not as a dean, but when I was a faculty member, I probably would have tried. It's the nature of the business you have. You can actually learn from if you pay enough attention and are careful about it. Anyway, so I think that to be skeptical, this is an interest that I agree with you. You do not want them going to see what's the thing? Zuckerberg. Even though Zuckerberg gave in about 1 second by being flattered by Trump, he's a chicken. But besides from all that, you don't want the government doing that anyway. You don't want them.
Professor Lane. So we'll turn to TikTok, which was all the rage, right? The TikTok ban that really bothered a lot of folks. So last year, the Supreme Court upheld the law banning TikTok's operation in the United States unless sold to a non-Chinese owner. I listened to the oral arguments. Has anyone listened to oral arguments from the Supreme Court? It's really neat. And these are arguments were particularly fascinating to me. But TikTok believed that the ban restricted its free speech and its users' free speech. Let's start with Allison. What are your thoughts on that argument and what, the Supreme Court upheld the ban, so they didn't buy those First Amendment arguments. What are your thoughts?
So really quickly, there's 3 types of scrutiny, which Massimo already sort of elucidated for you. Strict scrutiny, which is the highest bar to meet, which means that a law has to be narrowly tailored to achieve a compelling government interest in the least restrictive manner possible. And that's when a ban or a rule or a law against speech is content-based or other requirements. Intermediate scrutiny is where a law is aimed at something and is content neutral, and it can have time, place, and manner restrictions or things like that. And that has to meet a barrier of being substantially related to an important government interest. So my view on the TikTok ban is that there was 2 arguments for it. One was that it was a national security risk, right? Because they were farming information. China was taking information from the users, compiling it for, I'm not technical enough to know what the purposes are for, but nefarious, we'll guess. I don't know. But that was the argument for banning TikTok, right? It was a national security risk to allow American citizens to be seeding this information to a foreign-owned company, right? And so when it's my understanding that the Supreme Court, when they applied it, obviously are not applying strict scrutiny, because the ban on TikTok was not based on the information being provided by TikTok. It wasn't individual videos that the government was saying we don't want. It wasn't, I don't like this administration, or I don't want to drink Pepsi or Coke. It wasn't the content of their speech. It was the use of the information from the government, right? And so it has that lower bar to be met. And so if you can argue that national security interests is, meeting that intermediate bar, it's substantially related to an important government interest, then I think you agree that the ban should be upheld. If you don't feel like that is a true argument, or you think there was some other reason, then you can make that argument. But I agree with the ban because I do think it met the intermediate scrutiny.
So, the TikTok case is kind of interesting because the court spoke per curiam, meaning they all agreed. Which, if you know anything about, Sotomayor and Clarence Thomas, think different. So it's interesting. It's obviously very fact intensive. I don't know tons of details about the case because the court said, this is just a regulation of a corporation. And I know that the court was upset that they had that TikTok didn't bring any arguments. This is what they said. You didn't bring any arguments about previous cases regarding corporate controlling being the suppression of expressive activity, which would trigger strict scrutiny. And so national security concerns, whatever, very fact intensive. If it's true, if what the court's saying is true, if the plaintiffs, or defendants fail to meet that burden, and if it is narrowly tailored, then it kind of reminds me of in the Federalist Papers, they talked about how the court, why do we listen to the court at all? They don't have an army, they don't have the sword. What they have is their reasoning, right? I think Publius, one of the Federalist Papers, they talk about we listen to the Supreme Court, the justification for it is critical in us believing and listening to what they say, because that's what they have. They have their words. The executive has, the military, the police. The Supreme Court's not going to, send the police out to desegregate the schools. They're going to tell you why it needs to happen. And so in this case, the court said some stuff, seemed plausible to me. I can also see myself disagreeing if I look into it and go, no, this is expressive activity. And it's not narrowly, it's not, you should have applied a higher standard or something like that. On its face, there seems to be enough of a rational argument to justify it one way or the other. I might disagree if I really look at it carefully. I might say, no, this is political. This is, I probably lean that way. But they said, look, we're just stopping. This is just an issue about whether or not corporations can buy and sell things. It's not about the content of speech. So like you said, it gets intermediate scrutiny. Pretty big stuff, but I'm not really that privy to the facts really about what because how long is the case? It's pretty long, like 100. Very long.
What?
How long is this case?
The TikTok.
I don't know. Whatever.
This is beyond.
Okay. Well, anyways, I could see it being a restriction on speech. But we need facts to support that, right? Arguments. I think the Supreme Court's argument is at least rational, even if it's wrong.
It's still striking that we had everybody agree on that. So we'll let Professor Liam talk on that, and then we'll take questions from all of you.
I agree on that. I will say one thing, we don't have real time to the questions. Something Massimo said. So when they're doing the Constitution, writing the Federalist Papers, there is some reference to the Supreme Court, but nobody knows what the power of the Supreme Court is at the time. And there were many people that thought it should never have the power to review the constitutionality of statutes, which doesn't get solved for another 15 years, 10 years in the case called Madison versus Marbury. So the role of the Supreme Court actually, if you look at the Constitution of the United States, no reference to the fact that the Supreme Court should have the ability to declare a statute unconstitutional. So one justice was in a very funny situation, actually declared this, and it's become the rule. But here, one of the most important institutional institutions that we have is founded and based, its power is based on a decision by that institution. So without really any reference to the Constitution. So there you go. I agree with them saying that.
All right, so I think we're ready for questions.
Share the mic. I think we only have one mic in the room.
Okay, no problem.
Yeah.
I have two questions actually. From my perspective as the county clerk and recorder administering elections on behalf of the county. First of all, I get it, right to free speech, Facebook and public forums and all those things. The problem is that free speech has been abused to the point that there is very damaging misinformation out there, and it affects me and my team and our communities directly. And I just want to know, what can we do about that at all? We're trying to do our part as far as like neutralizing it with good information, but what can be done at the governmental level, if anything? My other question is about the Supreme Court has decided that campaign or campaign money is protected speech. And we've seen the damage that that has caused by way of Citizens United and what can be done to get money out of politics, to get good money out of politics.
$1 million question, how to get money, intended, giving money out of politics. Who would like to take on both questions or at least one of them?
So for your first question, the second one, that's beyond me. But the first question, right, the effects of free speech in practice, right? And so I understand the concerns that we have in the similar arguments have been made against hate speech, making that a protected category, right? Because there's real life ramifications to free speech. And probably my answer is not going to feel good or maybe even satisfy you at all. But my solution is more free speech. Because I truly believe that free speech is an inoculation rather than an indoctrination. And what I mean by that is, if you allow speech that is even dangerous or detrimental or disturbing or disgusting to be heard, it is my true core belief that my children or whoever's children, when they hear that speech, the answer is not to say they can't handle it or this country can't handle it or it's too dangerous. The answer is to say, let that speech flow so that then I can stand up and I can inoculate myself and everyone around me against it. I can come up with a better argument. I can show you A, B, C, D, E, why you are wrong, why you are violating core tenets of the Constitution, why you're violating our societal rules that we have agreed upon. If I believe that your misaligned message will indoctrinate my children, there's going to become a point where I don't allow them to hear anything. And I have too much faith in the strength of my children and your children and the society's mind to say that we have to protect people from that. It is a hard process, and it has been subverted by people who would like to silence us, like to silence the vote. But it is a long line, right? It is a long ride. And so if we are committed to the First Amendment, if we are committed to letting ideas be defeated in public discourse, I think we have to stick with that, even when it means that unfortunately people like you are faced with just reprehensible conduct. So what can we actually do? I think we as a citizenry can come to your aid. We can try and make reasonable accommodations, time, place, and manner that are content neutral, things that we already have in the Constitution that maybe we are not actually using. First Amendment protections of speech that we already have that maybe aren't being implemented to their fullest point. But I just truly believe that adding more speech to the list of unprotected ideas is not the answer. More speech is always better.
So real quick on the first point, and then a tiny bit on the second, but I'll just provide you an alternative answer. Sometimes not all speech is protected. There's unprotected speech. Some people call some of this lesser protected and some of it categorically unprotected. And I think a lot of us will agree that this speech should be unprotected. We have true threats, defamation, we have fighting words, which really is a dead doctrine, but it's still there. We have obscenity, right? No one comes up to your house and gives you, here's some obscene materials. That would be not, you don't want your child answering the door. There's rules against that. So we have plenty of unprotected speech. What could be done is well-crafted legislation in alignment with that to target things that have emerged in a way that was unforeseen. So you can use the existing doctrines in ways that you carefully think aren't. Well, then how are we individually going to do that? Well, we can vote. We can have state governments add protections. The Constitution is just the floor. The state governments all have their state constitutions. So we can vote for people who run on platforms to do certain things and protect us even more than the Constitution. They can't, collide with it. There's a supremacy clause. They can't subvert or take speech away, but there's ways to craft protections. The government has conditional spending. If they really want to, they can conditionally spend to promote. You're talking about misinformation. Maybe the government, we just vote for people who are big on fighting misinformation, and they don't do it by suppressing speech, but they do it by providing incentives to companies to deal with misinformation on their own. Perhaps that won't be coercion because they're just dangling a carrot, not a stick, right? They're just saying, look, hey, come on, we'll even help you out. You know, it's tricky. Maybe you'll violate the Constitution. Maybe the Supreme Court will knock it down. But if you're crafty enough and you vote for the right people who have those values, you can craft legislation. For instance, here in California, they are trying to deal with generative images we were talking about. Their first draft, I believe, was knocked down because it ended up violating the Miller test for obscenity. So now they're trying to craft another. They have this two-pronged thing dealing with AI undressing people, stuff that we all agree that shouldn't be. We don't want that. So you can craft things. You can figure it out. I don't think any free speech absolutist is going, maybe, but most of them aren't going to say, oh, well, you know, the categorical lack of protection for speech regarding that depicts harm to children. Oh, yeah, let's bring that back. No one's saying that because it's terrible. We agree. So there's carve outs that aren't protected. We don't allow defamation if the elements are met. So there's ways. They're crafty. A lot of it could just be voted. Right? It could just be voting and grassroots movements and hey, this is what we need to stop. We need to build a coalition and we need to vote people in power to do this and that. So, but not easy to do. And we could also just do it outside of the law by having these companies do it themselves, self-regulate. It doesn't always work. It can be terrible. It might not work at all, right? It might not work at all if it hurts the bottom line, but you could put pressure on them through your dollar. But anyways, so I would say that voting, crafty ideas, not just lawyers, but lawyers combining with other people to figure out ways to get rid of speech we think is harmful and impermissible without violating the Constitution. It's been done before. There's emerging things. We're gonna have to figure out our algorithm speech. You know, it's crazy stuff to think about. So, yeah, politics, I guess. Politics, government, every day. And I'm not gonna rant about Citizens United, but I'll pass it to the professor. But all I'm going to say is we have a doctrine in which we've said corporations are artificial persons in certain contexts, which is strange to say. What do you mean it's a person? Where is it, right? So, and money is speech. Okay, that we allow this to be speech under the O'Brien case. Symbolic expression is speech. As long as somebody else is reasonably going to think my expression conveys a message, then the court has said that's speech, and that's great. That's protected tons of stuff. But that combined with corporations being artificial persons and your dollar being speech has allowed, got us Citizens United, which is unlimited campaign contributions. It's kind of tricky, but that is obviously, I think most people think corporations funding politics is not good. We don't like that. So public funding of elections, transparency laws as to where the money's going. It's not an easy fix. Some people just say we've got to overturn Citizens United. I'll let the professor.
You were asking this question from the perspective of a government official. So you're from the right. So
I'm the elections official.
no, I mean I'm not offended by it, but I want to say I've been a government official off and on for years, so I'm respectful of that. But I want to my real answer to that would be good luck. Because with Citizens United, with this corporate in an elected capacity, in campaigns with this idea that corporations are people. I mean, it was a crazy decision in my view. And hopefully at some point we'll figure out a way to overturn it. But I want to say, listening to Massimo, when I was a law student, we closed law schools over the notion of the Vietnam War. Every law school in New York was struck against and closed, even night schools. And so I was thinking as Massimo was talking about, I now have the, let me say, skepticism of age, and he has all of the enthusiasm of youth. But I'm more, I think I'm probably too cynical about the capacity to get hold of some of these things like you're concerned about. And I certainly am skeptical, at least in this period, of self-regulation. If you had self-regulation, You know, it's like Madison said, if men were men, using the word man, no offense, he used it. If men were angels, we wouldn't need government.
Any more questions?
I have a question about, a lot of this issue about free speech. Essentially, it's intimidation and, essentially you have to go to court. That means you're going to bankrupt you. That's the threat. It's not, has nothing to do with what you say or what you do, is that they want to bankrupt you. And then that will silence you. My one concern right now is that I have seen some things on YouTube where there are people being impersonated with saying things that they wouldn't say. And so you have to make sure that you look at the channel that's coming from. So as a business owner, I'm concerned that my image may be used because I'm using YouTube, I'm using Facebook, I'm using Instagram, and I have a certain message for my business. And if that is now somebody is going to take my image and put words in my mouth, what can I do about it?
I think in California, you can go to your district attorney. Because I believe that California has and many states have laws about taking your image. The phrase you, so I think that would probably be a criminal offense, potentially, and also it's a civil offense also statutorily. So I think we do have steps to take, and nobody is allowed to take your image and put new words in it. Like, I think the whole issue of media, mass media now is real, and its regulation is going to be a big battle over the next 5 or 10 years, both in the states and in the United States, and particularly as AI develops. So stay tuned.
Do you have any thoughts?
Yes, I'm Jordan.
So there's a remedy eventually.
All right, I think we're actually out of time. Sorry to get the questions. Oh my goodness, what a very educational panel. Thank you all so much for being here and for sharing your time and thoughts today. Such a relevant topic. And if you're around for the next few minutes, maybe some of the folks who had questions will come and ask. But thank you again so much for being here.